The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. My name is Robin Kincaid. I'm from Nevada PEP. I'm the Educational Services Director. I want to thank you for joining us today. Our topic today is part of what we call the Ideas Series, and we're going to be discussing procedural safeguards. Thanks for taking the time to learn about this important topic. We're happy to have you as part of our webinar. And we encourage you to keep in mind that you can ask questions. There is a question pane that you should be able to see. And we have that open and are ready to take questions at any point during this broadcast. Nevada PEP is a parent training and information center. We are statewide. We're all parents of children with disabilities and understand the concerns and the questions that families often have if their child is showing delays or is not making progress in school. The procedural safeguards is a topic that often families either can be confused about or overwhelmed. They do receive procedural safeguard notices, and procedural safeguards could be utilized for families that have children in early intervention or for families that have their child in school ages 3 through 21. But sometimes we see those procedural safeguards as just a copy of a piece of paper and not really are very clear on what they mean. So we're hoping to add some clarity to that today and to help you be able to ask questions that gain you information so that you can help your child. Nevada PEP is a nonprofit organization, and again, we are statewide, so we're covering the entire state of Nevada. And we provide services to parents of children with disabilities or anyone in the community that requests our assistance and would like to either ask a question or would like more information about a disability. All our services are free, and we provide a variety of trainings in our locations, in the Reno Sparks location and our Las Vegas location. So we would encourage you to visit our center, to meet with one of our staff if you have more questions, and to continue to learn more on how you can help your child. So the screens that you keep seeing pop up are just a little more information about Nevada PEP. As a nonprofit that you do some fundraising to try to continue to expand our programs. We do a lot of work in helping families who may have a child that has been bullied. And we do a lot of work in the area of children's mental health because the types of disabilities that we encounter when we talk to families is a huge variety. So we have families that may call us that have children that have mobility issues or what we call sensory issues or are visually impaired or are deaf or hard of hearing. But we also have families that have children with mental health disabilities, and we are here to support those families and help them, which sometimes can be a very difficult journey because of working on the child's behavior, if they're using medication, to make sure that they get the appropriate medication, and just to find services in general for your children can be difficult in Nevada. So we're going to go through a series of PowerPoint slides. I'm going to change this back so that you can see the slides. So hold on one second. Okay, I think I switched it back. There we go. Let's pull up the PowerPoint for procedural safeguards, and then we'll switch that right back on again. Okay, so you should see the logo and our mission, which is, of course, to increase the opportunities for a home and community and school success for children with disabilities, including those who are at risk or have had serious emotional disturbances, their families, their service providers, through education, encouragement, and empowerment activities. Often the families that call Nevada PEP sometimes just want to talk. They just want to know that someone can listen, that they are aware of these kinds of concerns that families encounter, and a listening ear is often what families are looking for when they're making that phone call to our office. Here you see the procedural safeguards notice here. This training was developed by the Pacer Center, and we've added Nevada information to that so it will reflect the Nevada Administrative Code regulations. So it's important for parents to understand the distinctions between acts or statutes, rules or regulations, or policies and guidelines. Occasionally families will call and say, well, I was at the school today and someone in the administration told me that, I can't do this because it's against the law. And so families sometimes just say, okay. Other times they might say something like, well, I'd like to see that information so I can understand it a little bit more clearly of what you're referring to. Because it is important to know that policies and guidelines could be modified, could be changed, could be exceptions could be made for students with disabilities. Even rules and regulations, in some instances, if they're a rule at the school, could be, but acts and statutes cannot. And so the Individuals with Disability Act is passed in 2004. So regulations that clarify the statute have been written by the U.S. Department of Education. Individual states like Nevada have education statutes and regulations, which is the Nevada Administrative Code, to explain how they will provide services to children with disabilities. School districts have policies and guidelines in areas such as attendance, behavior, that all students are expected to follow. However, if a district policy or even a state law is in conflict with a federal act or regulations, they can be challenged and changed. One example might be zero tolerance policies. Those have been established in districts across the nation. Such policies often have harsh consequences for behaviors that school districts have specifically addressed in their policies. If the consequences such as expulsion or long-term suspensions are in conflict with a child's right to free, appropriate public education, the policy cannot be implemented. Parents who have concerns about policies and guidelines that lead to their child being unfairly treated can carefully examine and compare the policies to their state laws and the federal acts and regulations. Next, we're going to look at kind of an illustration of how these policies look. So let's start just with the outside circle, the 14th Amendment. Most of us may be familiar with the 14th Amendment because it was ratified in July 9th of 1868, and it granted citizenship to all persons born or naturalized in the United States, which include former slaves that were recently freed. In addition, it forbids states to deny any person life, liberty, or property without due process of law, or to deny any person within its jurisdiction the equal protection of its laws. By directly mentioning the role of the states, the 14th Amendment greatly expanded the protection of civil rights to all Americans and is actually cited in more litigation than any other amendment. So go further into the circle, we see the ADA, the American with Disabilities Act, and enforcement is provided by the government office overseeing each area covered by the act. The penalty for non-compliance could be the withholding of federal funds. And so the ADA has very different versions, like, for example, Title II is something that we've been looking at more recently, which in relationship to a memo that was issued called the Communication Memo, and the Title II protections are actually another way that parents could challenge the way that the school might be implementing or providing services if they felt that their child was not getting an equal access to communication. Going further into there, we see that 504, which is Section 504, is a statute for the Office for Civil Rights. And of course, penalty could be non-compliance as well. Children that have a disability which affects a life function might have an accommodation plan under Section 504, but they're also entitled to free, appropriate public education. In the center, we have IDEA, which is the Individuals Disability Education Act, and that's enforced by the Department of Education, the Office of Special Education and Rehabilitation Services. And again, penalty could be withholding of federal funds allowed in that act if the school or the state was not in compliance of enforcing the laws that are part of the regulations under IDEA. So as your child's advocate, it is important that you're able to participate with as much knowledge as possible. Learning about the different laws that apply to you and your child can help you advocate more effectively for the services that you feel your child needs. Often at Nevada PEP, when we're working with staff or we're helping families, we often go back to the phrase, what does the law say? Because we really have to use that as the foundation of being able to help families access the services that they need. As we continue to look at this slide, the NRS, the Nevada Revised Statutes, are very similar but maybe slightly expanded statute that was created in Nevada legislation. It may mirror IDEA or be very similar, but it allows a little bit more. It can't take away from what the federal law indicates, but it can add to it. And then, of course, on the right, the Nevada Administrative Code are the regulations that come from that statute. And so Nevada regulations, we often take a look at very closely along with IDEA regulations to help families understand what schools are required to do, and also our IEPs written, which are individualized education programs. Are they written in accordance with the Nevada Administrative Code and IDEA? FERPA, in the center there, is the Family Education Rights and Privacy Act, and certainly schools are required to use confidential measures in order to protect students with disabilities and their families so that individuals would not necessarily know that the person has a disability. So they must, access to records and just even conversations should be very much keeping in alignment with confidentiality, similar to how you might see in a medical office in relationship to HIPAA. But FERPA is an important part of laws, and those are enforced by the Educational Rights and Privacy Office, and parents could file a complaint if they had a concern that the FERPA Act was not being implemented in their child's school. So under IDEA, parents and children with disabilities are afforded certain rights in the special education process called the Procedural Safeguards. Those are those sometimes multi-page packet of information that's given to families. And so these are some of the requirements under the law of when the notice must be provided. Certainly, if families wanted to look at the notice, if they wanted a copy from Nevada PEP, we could direct them to where it's published on the Nevada Department of Ed website. So all school districts must use this similar format so that all of the information is in there. So the notice of the procedural safeguards describes the various rights that parents and students have, including how to resolve disagreements. These procedural safeguards provide the groundwork for parent participation in the special education process. So as we go further into this training, we're going to explain the dispute resolution procedures and related timelines, as well as strategies that parents can use to prepare for these processes. So schools must take the steps to ensure that parents have the opportunity to participate in any meetings related to their child's identification, evaluation, placement, or the provision of free appropriate public education. This includes scheduling the meeting at a mutually agreed upon time and place and notifying the parents early enough so they have the opportunity to attend. Schools must also provide the parents with a written notice before the meeting that includes the details of the meeting, and this is actually called a prior written notice. That's going to tell the families the purpose of the meeting, why are we having it, of course the date, the time, and the location. Families call our center on a relatively frequent basis and say things like, well, the school will only meet on Wednesdays at 6:30 a.m. and I can't do that on Wednesdays. And we talk about that it needs to be mutually agreed upon, and that it's important that parents might propose some other dates and times that they feel like they can meet and have the school try to work out. So there can't just be a unilateral date and time and that we only do IEP meetings at this time only. The school has the responsibility of working out a mutually agreed upon time. The prior written notice must also include a list of people who are going to be in attendance at the meeting. So it's important for parents to know who will be at the meeting so they can be sure that all of their questions and concerns can be addressed. The notice must also inform the parents of their rights to invite people to the meeting. So parents might invite a family member or a friend, babysitter, a behavioral therapist, an advocate, or even a Nevada PEP representative to come with them to the meeting. There's no obligation for the parents to provide notice for anyone they are planning on inviting to the meeting unless the parent is actually inviting an attorney to attend. Like we discussed, parents must receive a copy of their parental rights, again, at least one time per year. School must also take steps to ensure the parents understand the proceedings of the meeting. This includes providing an interpreter for parents whose native language is other than English, or for parents who are deaf and hard of hearing. To ensure that an interpreter is present, it is a good idea for the parents to remind the school that this accommodation is necessary. This could also be a situation where the parents also need for the pace of the meeting to be slowed down so that they have an opportunity to understand the meeting. So if, for example, if the parent has a learning disability or struggles in reading, then the school still has to ensure that the parents understand the meeting and the meeting process. Here's that prior written notice, because there are other times when the parent should receive that. Just as the parents have to be provided with an opportunity to participate in decisions relating to that identification, evaluation, and educational placement, and the provision of FAPE. They also must be given the prior written notice anytime when the school proposes or refuses to initiate or make changes in this area. Some examples might include when the school refuses to initiate an initial evaluation for a child for special education services after the parent requests one. When the school proposes to change the child's educational placement. Or when the school refuses to increase the frequency of a related service. So IEP teams should work together to come into agreements in these areas as much as possible. Sometimes IEP teams disagree. When parents and schools disagree, there are things you can do or say that will help the disagreement be solved more quickly and amicably. You can disagree without being disagreeable. Parents can express that they want to continue to work together for the benefit of their child, and they don't want this disagreement to interfere with that. So remember, you're an advocate for your child. The professionals that you may disagree with work for the school district and must not only answer to you, but to their bosses and administrators. Oftentimes, it's not the person that you're disagreeing with at all, but the school district. So you want to try to separate the person from the problem. Each person involved in the disagreement brings different information, values, and experience to the table. No one person has all the answers. Try to work together using everyone's input to resolve the problem. Another thing to remember, that not every issue is worth disagreeing about. You want to choose your battles, and those that you're working with might become wary and frustrated if you are kind of focused on way too many issues. People can't stay focused on what is really important. So you want to try to stick to the issues that really affect the quality of services for your child. Still, sometimes more formal dispute resolution procedures are necessary to resolve disagreements. The rest of this training is going to focus on how to resolve those disagreements using the formal dispute resolution process outlined in the Procedural Safeguards notice provided to parents under IDEA. So sometimes it may serve the family well to just have another IEP meeting. I mean, that's another option, is to just meet again. But if that doesn't work, then we need to talk about what these next steps are. So one of the options that families can file without necessarily changing the result of the previous meeting is just mediation. Mediation is a voluntary process that brings people together to resolve disagreements. A mediator helps participants communicate with each other so that everyone has an opportunity to express their concerns and to offer solutions. Parents and educators, again, must both agree to participate in order for mediation to happen. Likewise, participants may leave the mediation at any time. If both parties agree, a mediation session will take place at a time and in a location that's convenient to both the parents and the school district. Parents and relevant staff from the school district will meet with a neutral mediator who will help facilitate communication and come to an agreement. The mediator does not make decisions and doesn't favor one party over another. Instead, the mediator helps to guide the problem-solving process by creating a safe environment, encouraging participants to be respectful and understand other points of view, and clarifying points of disagreement. The mediator may also help to identify options and assets with writing down any agreement. So when there is common ground, the mediator might quickly write down, oh, common ground. If a dispute is resolved through the mediation process, the agreement must be in writing and signed by both parties. The written mediation agreement is legally binding and enforceable in state or federal court. Mediation discussions are kept confidential, so what is said in mediation cannot be used as evidence in a due process hearing or a civil lawsuit. But some benefits of mediation are that mediation can help everyone understand the other's points of view. Participants work on solutions together and in control of the outcome rather than someone who doesn't know the child is making a decision. People tend to be more satisfied and follow through with the terms of mediated agreements because they're developed together. Disagreements may be resolved more quickly than with other dispute resolution options. And mediation focuses on creating a plan for the future. So families may want to consider the mediation because they know it's a safe place and they know that it can't be used against them later. So it's just another way of being able to work on resolving that issue. So kind of how to prepare for mediation, organizing the documents, write dates and notes on them. You consider making, some additional copies so you can actually share the information. You want to make a list of these issues and questions you want to discuss during mediation. It can help you remember all of your concerns. You can present them in an organized manner. You want to kind of think of the questions that other participants might ask and write down some possible responses. You also want to try to think of some different solutions to the problem and write them down. You might even be exploring the idea of some more saving face kind of solutions where the other party, you can give them an out. Perhaps maybe the answer is that the individual that is part of this issue, that maybe they get more training. You want to think about how you plan to deal with your emotions and others during the meeting. Try to arrive a little before the scheduled meeting time so you have time to get ready to participate. Of course, mediations more likely result in an agreement if everyone listens carefully to one another and is respectful. And often there is periods of time where only one person is actually going to be talking, and the rest of them must listen. They can't interrupt, they can't argue back. So there usually is these periods of time where the family has a chance to present their concerns and their questions and the reason why they're there. And then the school might have a bit of a rebuttal or ask some more questions or give their perspective of why they're so convinced that what they're offering is appropriate. Mediation can sometimes be emotional, tiring, and frustrating, but it also can be helpful to have someone next to you. So you're not feeling as though that there's 6 of them and 1 of you. So having certainly the child's other parent or having an advocate or someone from Nevada PEP could also be helpful so that you don't feel like you're doing this in so much on your own. So parents could consider requesting a due process hearing complaint, and they can request it in, of course, any of the areas of identification, evaluation, educational placement, or the provision of free appropriate public education. When parents or school districts have concerns with these issues, they can submit a written letter filing a due process complaint. So both school districts could file due process and parents could file due process. The majority of the due processes that are filed are by parents. This process starts a whole, the process could lead to a formal hearing, and actually where a hearing officer decides the outcome. But there are steps along the way before you get to the formal hearing that we want to make sure we talk about as well. So after the parent requests the due process hearing, the letter is received. The school district's going to respond to it within 10 calendar days. School must schedule a resolution meeting to take place within 15 calendar days. So relatively quickly, you're going to be at the table talking with maybe representatives of the school, talking with representatives of typically like a compliance and monitoring department, and so that you have a chance to prepare your concerns and why you filed the due process. Parents in the school district could agree in writing not to have the resolution meeting or to use mediation instead. That is a possibility. Refusing to do resolution, though, can be certainly a concern as you go further into the process. The hearing officer might ask questions. The school might say we wanted to meet, but they wouldn't meet. So we really want to think about that carefully of why not do the resolution session. So the resolution meeting or session is a dispute resolution process. It takes place after the parent has filed the due process complaint. This is an opportunity to resolve issues before the actual hearing happens. Resolution meetings are an important opportunity to communicate and improve the relationship between the family and the child's school. It's a meeting between the parents, probably someone from the school district, who make decisions on behalf of the school, and members of the IEP team with knowledge about the facts relating to the due process complaint. Parent may choose to bring, an advocate, an attorney, or any support person. Again, it has to take place within those 15 calendar days. So parents would want to get ready for that. They would want to go ahead and get their opening statement ready so that they could talk about their concerns. They're going to want to have maybe some proposed ideas and solutions of how this issue could be resolved. Maybe it's about collecting more data, providing more training. Those are all ways that the school district might be open to help resolving the issue between the family and the school. Sometimes there can be situations where there are major misunderstandings that result in due process complaints being filed. It could also be a situation where the school did not have enough guidance or technical assistance and made some decisions without good input from the family, and still may feel they made a good decision, but the family says, no, my child still really needs, for example, this type of placement. And the school says, well, we think this one would be better. The family says, well, how are we going to meet the needs in this area if we go to this placement? So there's a lot of questions that the family can bring up that might help generate that conversation in a resolution session that would help quite a bit in being able to get to a point where the school could revisit this. Of course, any decisions that are made, either the school or the parents could reconvene the IEP. Okay. So that resolution meeting is happening before the due process hearing, working to resolve the disputes. Yes, due process hearings can have a long-term negative relationship, possibly, but they often can help mend some relationships that have kind of fractured in IEP meetings as well. So they're, both can have an interesting effect long term. Okay. Some of the questions that get answered in a due process hearing is, whether or not the child received free, appropriate public education. And so some of these questions, did the concern impede the child's right to faith? And did the concern substantially impede the parent's participation? Was it a situation where the school prepared the IEP and the parents didn't get a chance to be part of the development? And so did the concern cause a deprivation of educational benefits? Remember, the hearing officer is neutral. They are knowledgeable about IDEA, and they're looking at the facts of law. And there could be witnesses that are part of this due process hearing. So this is a pretty formalized process. And certainly parents that file due process hearings and intend to go to a hearing really do need the advice of an attorney that can help them prepare, since there is, could be processes such as subpoenaing witnesses or doing depositions or doing witness interviews, and all of that requires the skill of an attorney. So one of the things that we would provide would be a list of attorneys that do due process hearings, or at least participate in this, so that the family has some additional help. But there could be a cost involved for the family, and so due process hearings sometimes are frightening to some families because they could have the cost involved. So due process can be adversarial at some point. Less collaborative dispute resolutions options are available. Certainly looking at mediation and due process is typically to resolve a dispute over an amount or a type of service. Sometimes it could be filed if the service has not been provided, but there are other remedies, such as a state complaint, that could help the family when a service has just not been provided or implemented in the IEP. So certain issues that are concerns to parents might not be appropriate for a due process hearing. So it's important to kind of understand if the issue is really related to IDEA. And so example might be that if the family did not like the location of the school or the teacher, or was unhappy with someone within the district itself, a due process hearing isn't going to resolve that. And keep in mind that the hearing officer doesn't know your child, so they're making a decision, and that's why it's better to look at these other services or other dispute resolution process, because then you have more of a say in them and you can participate in them more actively. Where often in a due process hearing, now you've handed it over to an attorney and to a hearing officer. So these are ways to prepare for a resolution or a due process. You want to, again, you have to get very organized with all of your documentation. You want to make sure that you have all of your records from the school, and identifying those concerns and solutions. You want to organize the documents. You're going to practice what you're going to say at the resolution session, and then you're going to try to work through a solution and try not to react to others and even their behavior. I remember years ago I was in a resolution session and one of the administrators sat down and she had an enormous purse in front of her at the table. And her body language was so much that she was closed off that no one would even address her because she was really not present because of that. So you have to remember how body language plays a role, and that tells the participants that you're really closed off to any discussion. Whereas the meeting is more likely to result in agreement if everyone listens carefully to one another and is respectful. Resolution sessions are often done by an administrator who respects the information that everyone brings, and that person, if they handle it well, then there are resolution agreements that can work for families. So the written state complaint is another way that families could file and as part of a dispute resolution process if the services within the IEP were not being delivered, or there's some disagreements regarding the eligibility. So it is the only dispute resolution option available to a person or an organization. So an organization could write a state complaint as well, but typically most state complaints are written relating to a specific child. Often in those complaints, there is a whole process that families need to follow. There has to be information that may appear to be redundant, but must be included actually incorporated into the state complaint request that is sent to the Nevada Department of Ed, as far as like where the child lives and other pertinent information. So parents who believe their child's school has not followed the requirements of IDEA are writing these state complaints to the Nevada Department of Education. A copy also needs to be sent to the school at the same time. And as a reminder, any of these processes that we have discussed today also apply to charter schools as well. So families could file due process if their child attends a charter school or if their child attends just a public school. So as you can see on the slide, there's some different information that needs to be on there. And so they're looking to find out what are the facts, what laws have been violated, and some suggestions on how to resolve the issue. So after the state complaint is filed, their Nevada Department of Ed must conduct an investigation and make a decision about the complaint. And then parents are going to get a written response and also some suggestions on other ways to resolving the issue. So if there are things in the complaint that again are not state complaint issues, they'll clearly be identified that that is not a state complaint issue. Once again, if it's like I want a different school, that would not be a state complaint issue. So if it's also received without the required content or it's not signed, that could delay the whole process. So the final written complaint decision includes facts, conclusions, and a list of reasons for the final decision. The decision is made no later than 60 calendar days after their written state complaint was received by the Nevada Department of Education. Just to let you know too that on the Nevada Department of Education website, there are state complaints that the public could review. Of course, the names and the school itself have been redacted, but you could certainly see the types of issues that parents have written state complaints on and the findings that occurred. So if there's like a finding, then the school has to submit a corrective action plan. in order to, some of that could include at some point, again, compensatory or other remedies. So you could use mediation instead to resolve the issue, because you would most likely be able to get a mediator and a mediation scheduled much sooner than that 60 days. But you only have 1 year to file the complaint from when the date of the incident. You can't be going back 2 or 3 years. Another dispute resolution could be to request an independent educational evaluation. And so if parents disagree with the evaluation results, then they could have someone outside the school system in the community evaluate the child. And that's called an independent educational evaluation. So they could help select the person once they request this independent educational evaluation. And Nevada PEP has sample letters related to all of these dispute resolution processes. Then they would send that to the school district and indicate that they disagree with the evaluation. The district can ask why, but the parents are not obligated to share that information. And then that outside evaluation, once that moves forward and the district agrees to go ahead and get that done, then those results come back and the school district and the parents discuss the results of that evaluation and how we can use that information to help the student. If the district disagrees with the request and says, no, we think our evaluations is correct and we don't really see any reason that we should be looking at independent educational evaluation, then they must file due process on the parent and take it to either resolution or to a hearing to demonstrate why they believe their evaluation meets all of the requirements and that the family should not have the right to have an independent educational evaluation. So it's important to remember that both parents and professionals have the same overall purpose and goal. Parents and professionals should try to work together as partners by, making an effort to communicate clearly, bringing different skills and information to the endeavor, having respect for what each partner brings to the relationship, having opportunities for giving feedback to one another, being accountable for the decisions made, using problem-solving strategies as early as possible to work on what went wrong and how the partners can fix it. Parent knowledge and options and opinions are valuable. No one else knows what you do about your child. You're the only person who has a long-term, in-depth, daily relationship with your child. By learning more about your rights in the special education process and advocating for what you feel your child needs, you can make a great difference in your child's life. Once again, we're opening up that question pane. We're just about completed with this. So we just wanted to certainly ask if there's any questions. I also want to remind you of the handouts that you can download off the GoToWebinar. There are handouts there that you can look at. Procedural safeguards can be complex and can be confusing for families. And we're here to answer questions. We encourage you to call our center if you have additional questions about procedural safeguards. There are many ways to resolve disagreements. So families sometimes feel like that they don't have any options, and we want to make sure that you know that you do have options and that there's always, various ways that we can try to resolve problems. And so don't give up or don't get discouraged if you feel like that the school is either not listening to you, or your child's not making progress, or your child's not in the right placement. Those are all concerns that families have, and you want to become more skilled at trying to address these issues. You're there for the long haul. As a parent of a child with a disability, we're continuing to advocate for my daughter as she goes into her 20s, and we will continue to help her access the different services that she needs. Don't give up. Continue to ask questions. Continue to seek out help and assistance. Nevada PEP is here for you. We serve families that have children from ages 0 to 26. So we're here for the long haul. So please, we encourage you to attend another one of the webinars. We encourage you to attend a workshop or class that we have at Nevada PEP, and we hope to see you soon. Please visit our website, nvpep.org. We hope you are receiving our e-post and e-communique newsletters, which we send out each month, so that you can get the most current information of what's happening in the disability world, and certainly even what's happening in Nevada. Thanks for joining us today. We hope this information was helpful. We hope that you feel like you've been able to learn a little bit more about procedural safeguards. Again, we want to thank you, and we hope you have a wonderful day. Goodbye.